Well, the genesis of the current constitutional crisis can be traced to the delays in the holding of elections to the Punjab Assembly. We saw that earlier there was a confusion as to who was the constitutional authority responsible for setting a date for the elections to the Provincial Assembly. We saw that this controversy reached the Lahore High Court, where the Lahore High Court held that it was the Election Commission which, in consultation with the governor, had to announce a date for the elections. Nonetheless, we later saw that this decision of the Lahore High Court was challenged through an inter-court appeal before the same court. Nonetheless, during the pendency of that appeal, a suo motu case was initiated by the Chief Justice of Pakistan, and a 9-member bench was constituted by the Chief Justice to perhaps resolve the same controversy. Now, we saw that after this 9-member bench was constituted, instead of laying this controversy to rest, this controversy was only aggravated. So we saw that 2 members of the bench recused themselves from hearing this case because they had in fact recommended that the Chief Justice take suo motu cognizance of this case. So as a result, there was a concern that their opinion, their minds had already been made. And as a result, there was a concern that their continuation on the bench may jeopardize the right to fair trial of the parties before the court. We saw that on the very first day, 2 judges of the court perhaps said that the petitions and the suo motu case before the court was not maintainable because a decision had been rendered by the Lahore High Court, and the Supreme Court could not, in its suo motu jurisdiction, sit over a decision of the Lahore High Court and perhaps act as an appellate court while exercising its suo motu powers. So on the very first day, we saw that 2 members of the bench held that the petitions were not maintainable. Subsequently, after the case was heard, 2 members of the bench also joined the earlier 2 members and said that the petitions were not maintainable. So as a result, the Supreme Court dismissed the petitions and dropped the suo motu proceedings by a majority of 4 against 3. Nonetheless, we saw that there was also confusion as to what the order of the court was, whether the petitions had been allowed by a majority of 3 against 2, or whether the petitions and the suo motu proceedings had been dropped by a majority of 4 against 3. Now, the one fundamental difference in the 3-member decision of the Supreme Court was from the Lahore High Court was that the 3 members of the Supreme Court held that it was the president who would decide the date of the Punjab elections, while the Lahore High Court had held that it is the Election Commission in consultation with the governor that decides the date of the polls. The Supreme Court, or the 3-member minority opinion of the Supreme Court, was that it is the president who decides the date of the Punjab polls. So after this decision, we saw that the president announced the date of the polls on the Election Commission's recommendation, pursuant to which the Election Commission announced a schedule for the Punjab elections. Later, the Election Commission, through a notification, withdrew that schedule. Nonetheless, the controversy reached the Supreme Court once again, where a 3-member bench of the Supreme Court restored the Election Commission's schedule. Now, it is important to note that this schedule was announced on the basis of the date which had been set by the president. Nonetheless, at this point, because the suo motu proceedings and the petitions before the Supreme Court in the first round had been dismissed, the only valid and binding judgment is that of the Lahore High Court, which says that the date of the elections has to be set by the Election Commission in consultation with the governor. So as a result, the date announced by the president has no legal force. That date is without any effect, and any schedule announced in pursuance thereto also has no force in law. Now, we have seen this situation at the Supreme Court is perhaps unprecedented. We have never seen the Supreme Court as polarized, and we have never seen the Supreme Court to be as divided. So the controversies before the Supreme Court, whether the first set of petitions were dismissed by a majority of 4 against 3, or whether those petitions were allowed by a majority of 3 against 2, these questions. And one other question that was raised during the first round of suo motu was whether or not the assemblies were constitutionally and legally dissolved. So if, for instance, the Supreme Court was to hold that the dissolution of the assemblies was unconstitutional, then the requirement to conduct elections in 90 days would not accrue. The requirement to conduct elections in 90 days follows a valid and legal dissolution of the assemblies. So as a result, All these questions. Now, let us also bear in mind that none of the judges of the Supreme Court have held that elections should not be conducted in 90 days. Nonetheless, all these questions, whether the assemblies were validly dissolved or not, number two, whether the Supreme Court's first decision in this respect, whether that was by a majority of 4-3 or 3-2, these are questions that can only be determined through a full court, which is why it's imperative that the Chief Justice constitutes a 13-member bench of the court to address and resolve this controversy. Now, it is important to note that the Supreme Court at this juncture has 15 judges. Nonetheless, given that 2 judges of the court had recommended that a suo motu notice be initiated in this respect, their minds have already been made. So as a result, the Chief Justice ought to constitute a 13-member bench of the Supreme Court so as to resolve these controversies. Because in the absence of a full court, not only will the Supreme Court be unable to steer Pakistan and this country out of this political thicket, the Supreme Court would perhaps also be unable to address the chasms which have developed between the court itself.